Ladies and gentlemen, it gives me great privilege and honor to introduce you to the moderator of today's session, the first session, Professor Hassani Muhammad Ali. Professor Hassani Ali is a professor of law and faculty of law, University Kebangsaan, Malaysia, National University of Malaysia, whose faculty he joined in 1994 as a tutor, where he began teaching in 1996. He has been a deputy dean from 2012 until 2014 and reappointed in 2018 until 2019. Professor Hassani teaches company law and related areas including corporate governance, securities, regulation, and insolvency. His research and writing focus on main themes of corporate governance and corporate responsibility. So it is our honor to have him here on this wonderful occasion. Welcome, Professor Hassani Muhammad Ali. You would please take the floors from here as a moderator.
Thank you, Prof. Lata, for the kind introductions. So I hope I am audible, and I hope I can. Okay, thank you. So thank you for the organizing committee of this prestigious conference. I've been delighted, and I've actually very passionate to listen to the first keynote speaker by Professor Mahmoud Hassan. Now the session will continue with another 5 more papers, and I've been told to strictly monitor the time, unfortunately, because especially today is Friday. So we got a few papers here. So first and foremost, our paper will be delivered by Khaled Ahmad Chowdhury. The topic is Rethinking Arbitration Challenges Faced and Reforms Needed in Bangladesh. Interesting things about his background. He is a barrister of Lincoln's Inn with 29 years standing as an advocate, Supreme Court of Bangladesh. He is the head of chambers at the Dr. Khaled H. Chowdhury and Associates, dispute management specialist. Apart from handling diverse clients home and abroad, Dr. Chowdhury also served as a legal advisor to various impressively multinational companies and the ministries of the government of Bangladesh. He's also a fellow of the Chartered Institute of Arbitrators, which topic that is going to deliver today, and also a panelist in a number of globally recognized institutions, including ADR, ODR, AIDR, AIAC, CEDR, and numerous more. I think it is not justice for me not to introduce him fully, but because of the time limit, I think I would like to call upon Dr. Khalid Hamid Chowdhury to deliver his speech. So, Dr. Khalid, the floor is yours.
Okay. Early good evening from Dhaka, Bangladesh. Thank you for the kind invitation to be able to speak here today. It's an August occasion with many luminaries. I heard a few of the sessions yesterday, quite interesting and challenging. Now, talking about arbitration and challenges faced in Bangladesh and some needs for reform, I'll speak generally. Firstly, Arbitration Act 2001 has a potential as the most preferable method of dispute resolution in Bangladesh. It incorporates from the idea of the UNCITRAL model law. And UNCITRAL model law is the genus of many arbitral forums globally. And the Act of 2001 is largely based on the UNCITRAL model law. It is aimed to be the most powerful means of ADR, alternative dispute resolution, so that least interference by the courts, party autonomy, I would say independence of the tribunal, fair expeditious resolution of disputes, easy enforcement of awards. These are the salient aims and features, to start with. But our law, obviously, is, I would say, the law is there, but we are still developing as an arbitration culture for various reasons. I'll try to shed a few lights on that today. Now, our law doesn't actually resemble the model law. For example, when it comes to the definition of international commercial arbitration, our law slightly differs from the model law. And also there is a vexed issue of whether our courts can give interim relief to an arbitration which is not seated in Bangladesh, right? And that also has led to a number of diverse judicial decisions. So therefore, that's the other thing. Now, challenges to arbitration, I'll be focusing straight away. Firstly, I would say that since we have got the law which covers both domestic as well as international commercial arbitration, and also it deals with arbitration seated in Bangladesh, obviously, and in some cases, arbitration seated outside when it becomes an award, how to recognize and enforce an award, important. So this interplay of different laws, forums, and involvement of the court, I would say it has made the practice quite complex. And it of course, there are calls for changes. For example, the cost of arbitration, the cumbersome execution process of arbitral award. In some cases, the lack of clarity in the provisions of the Act, ambiguity in terms of granting interim relief. These have been I would say, the key problems. For example, in the case of domestic arbitration, an application may be made after the award is given before the district court. Whereas in case of international commercial arbitration, if an award is given in Dhaka, then you go to the High Court, right? So this interplay of the different forum often leads to a recipe for confusion. And not only that, we developed arbitration with the idea that it will be final, binding, so that people follow. Now, once an application is made under Section 42, there is a further provision of appeal under Section 48, even in case of domestic arbitration, when, let's say, the court refuses to set aside the award, etc. Which means we are actually having more and more courts in the arbitration. So we are not, seeing the finality so that someone getting the award can reap the benefits of it. So I would say that, again, I already shed some light on the execution, or I would say enforcement process. So once you get the award, then of all the things, we have the Code of Civil Procedure for the execution, which we all know in Bangladesh, where we stand in terms of civil litigation. It takes years to settle, isn't it? So, I mean, if a simple money decree might take 3 to 5 years in the lower courts. So when the arbitral decree award holder is going to the district court, even in an international commercial arbitration, I mean, that is, so to some, is the start of the agony rather than the end of the agony. So what to do? Why not have something, in the High Court division with more expert specialist judges to deal with at least execution in case of international commercial arbitration? That is another point. And again, you will see that other side can also file an appeal under Section 48 from the execution and from the level of execution. That means another era, another tier is added before actually you can see the award. You can enjoy the reaps of the award. Ambiguity in the Act, of course, I would say that in a number of provisions, there are issues. For example, there are 3 types of orders that can be appealed under Section 48, I just said. One is someone can appeal to the High Court in an international commercial arbitration, also domestic arbitration, and also an arbitration seated in Bangladesh, which is international. But it doesn't say much about what happens in an international commercial arbitration seated in Dhaka. Now, we have to apply the Article 103 of our Constitution to make sure that appellate division can actually decide those appeals. So Section 48 is silent about one kind of appeal, right? So that is an ambiguity. Perhaps the framers could have seen that at the time of promulgation. Also, we don't know, for example, when you are challenging the award, we all know the salient features of ancestral model law. There are some fixed grounds under which, firstly, one can challenge an award to be set aside at the law of the seat, where the arbitration is taking place, and also further at the place of the enforcement. See, the place of the seat is Singapore, and enforcement is in Bangladesh. Obviously, one can challenge the enforcement in Bangladesh, right? Now, there is this question of public policy, right? An award may not be recognized or enforced if it's contrary to the public policy of the country. Now, again, the Act doesn't define what public policy is. But again, public policy, I heard yesterday, and we know there is a very serious and complicated notion, never easily defined, because public policy may mean different things to different jurisdictions because of the, I would say, the political climax, the culture, and so many other things. And often it leads to a lot of controversy, right? So I would say that one of the issues. Now, also, since we are regularly practicing in the court of law, also in the academia, and also sitting as an arbitrator or acting as an arbitration and mediation counsel, we all see on countless number of occasions, parties are filing writ petitions in arbitration matter. I mean, when it is arbitration, isn't it? It's a private dispute resolution. You have agreed to settle your dispute outside court. Until and unless a fundamental rights is affected, I mean, the High Court division, with all due respect, should not be encouraging lightly on the Article 100 application, because these applications should be dismissed with all due respect at the maintainability level. But often we see writ petitions are prolonging the life of arbitration. So you file one writ after the other, one miscase after the other, and then you are sent back to the court of law. Currently, I am in a litigation only on a simple issue that someone got the award and there is a 60-day strict time limit to file an appeal or to challenge the award. Now, this is ICC arbitration, sole arbitrator seated in Dhaka. So the party who lost the arbitration filed an application to the ICC saying, please interpret the award. ICC asked them to pay a deposit of $5,000 because it's their administrative cost. This party did not, submit the cost, pay the cost. ICC very naturally said, your application is withdrawn, right? Now, after that application is withdrawn, after that date, 2 months later, they file an appeal in the High Court division. High Court very naturally refused, saying it is time barred because the award was given in November. You have filed the application now in June, right? Challenging in June. And they said, no, time must be counted from the date of the withdrawal of the application. Obviously, how can you call it an interpretation when you did not even cross the threshold? What is very important for us to understand, this dragging of the matter to the highest court from the High Court, taking 3 to 4 years, obviously it is a pain and agony for the arbitration parties, isn't it? I mean, so this is the problem. I'm also seeing another arbitration where in one domestic arbitration, the tribunal was formed by the court, award was given. Now, after the award was given, without filing an appeal, without challenging the award, the same party who lost the arbitration goes for another arbitration in the district court. And this court did not know about the earlier arbitration, right? They suppressed the fact. And tribunal was formed. And now we are going to the High Court challenging the second tribunal, right? Now, in the High Court, it's found out that the first court was a court of the joint district judge, not the court of the district judge. So comes the question, can a joint district judge's court, right, order formation of a tribunal? A very interesting question of law. But you see, because of the lack of law reports, because of the fact that we really don't know what's happening in the world of arbitration, it's very private, very confidential, but it is coming at a high cost. So this is one point. Quickly, the practice of arbitration, we know that practice of arbitration, please, I apologize for my word, it is a monopoly. It is like a monopoly of a few number of people. I mean, when someone is retiring and then they are having a dominance in the arbitration field, they have that adversarial mindset, not the ADR mindset. At the same time, most of the top law firms, the senior counsels appearing as an arbitrator or as an arbitration counsel, they're spending 80% of their time in the court of law. and suddenly they become an ADR experts. So how can you change your hat so quickly and become a very supporter of an ADR? So this adversarial mindset means often we end up advising parties to go and challenge in the court. See, let's assert my right. But this is not what arbitration should be all about. So my humble submission or suggestion would be that we have to change the academic mindset at the undergrad level of the universities so that our students are taught ADR at the most basic level, more seriously, so that our students, when they graduate, they should have that, pro ADR mindset, go for negotiation, go for mediation, go for adjudication, go for arbitration. Do not think about the court of law until, it is necessary. So therefore, students should be taught at the contract formation level, prevent the matter to go to court unless it is essential. So this is what, from my academic point of view, I must say, because otherwise it is, again, I would say the agony of the parties is humongous. Sometimes I see people saying, is ADR an alternate or additional dispute resolution? Tell us about it, right? So this is the level of frustration. Again, cost of arbitration. Cost of arbitration is another very, I would say, serious matter. Often the costs are not visible, hidden costs are there, and obviously it is not reflected in the award. Very quickly, interim relief. As I said, in an arbitration seated in Bangladesh, I'm seated in, let's say, Singapore or Kuala Lumpur, or London. If an arbitration proceedings are ongoing, and if one of the party in Bangladesh is siphoning the money outside Bangladesh, transferring the money, fearing loss in the arbitration in the foreign country, if that party comes to Bangladesh and says, freeze the bank account, freeze the assets, grant the relief, can that be done? Again, I said, our High Court was severely divided. In 4 or 5 decisions, they have said, our law on strict interpretation of Section 3 of the Arbitration Act cannot give such interim relief because it applies only to arbitration seated in Bangladesh, not outside Bangladesh, but only when an award is given and you are enforcing the award in Bangladesh, only then interim relief can be given. Whereas 2 or 3 of the recent judgments went against it. Then our Honorable Chief Justice ordered a larger bench, and the larger bench in the end have settled the issue, saying, no, our Arbitration Act is not empowered to entertain such applications. What happened in India? In India, they also face a similar problem, but they changed the legislation in 2016, and after that, the Indian courts are now empowered to grant.
Apologies, Dr. Khaled.
Yes.
2 minutes. 2 minutes
Yeah,
more.
2 minutes. Yeah.
Apologies.
So that is the point, that we need to have legislative intervention as well. Now, having said the suggested reforms, look, I think there should be an institution where an arbitration council can be there with a panel of arbitrators statutorily, so that they are qualified, they are trained, their ethical standards are beyond question. This is the other problem, because it is a very private sort of dispute resolution. Often a lot of things are happening which we cannot even share, even in the forum, right? So this leads to unfairness, objective and subjective unfairness. Secondly, legislative changes I just suggested, and there is no time limit. There is no time limit. In India, they fixed a time limit, and it has been successful when thousands of arbitrations are taking place, and our arbitrations are taking place 3, 5, 7, 8, 10 years down the line. Why can't we set a time frame? Also, there is no capping of cost. There is no capping of fees of the arbitrator. Please, let's think like this. If a 5 crore taka claim has a cost of 1 crore in arbitration, why would you go for arbitration? As simple as that. It's much better to go to the court of law and have that sorted, even if that takes longer. Therefore, such reforms are needed. But in the end, last 30 seconds, I think we have to have a change of mindset. Lots of academic luminaries are here. I would, humbly submit that we have to think from year 1 of our undergrad LLB, not when we retire. so that we have that, the progressive mindset that litigation is about helping people. Litigation, the job of the lawyer is to give a service to the profession, not just to think, narrowly and within the shackle. I think I'm privileged to say I finished on time. Thank you.
Yes, well done, Dr. Khaled. So, yes, thank you for sharing with us your industrial insight relating to the arbitration, which is quite universal. I believe there will be one or two questions that we can entertain.
If I can have the privilege of asking a very quick and brief question.
Prof. Yes, Prof.
Dear presenter, there is concept of place of arbitration and seat of arbitration, that these two things are not same. Under the Arbitration Act of Bangladesh, as you say, Article Section 3, the Supreme Court doesn't entertain any application for what is called a review or claim, whatever, interim claim. So my question is, if as you said, if the seat is in Singapore, and then the application for interim relief comes to the Supreme Court of Bangladesh, then this seat, the concept of seat, do you use in the sense of place or in the sense of seat? Seat means, as you understand, we accept the jurisdiction of Bangladesh to interfere in the arbitration proceedings, right? So even if the judge, the arbitrator sit in Singapore, still Bangladesh court has the jurisdiction to interfere, right? So I would like to please you to clarify this point, the difference between seat and the place of arbitration. Thank you.
Thank you. A very interesting question, sir. I mean, what my knowledge and my experience says that seat can never be changed. Once the seat is fixed, seat is the concept with which the arbitration is legally connected. So when an arbitration, the seat is decided by the parties, why we choose Singapore? For example, sometimes we choose a third country seat for neutrality. Singapore is very famous for its pro-arbitration regime. Therefore, once an arbitration is seated in Singapore, even if an application is placed in Dhaka, that doesn't change the seat, and seat and place are the terms used interchangeably. However, sometimes a tribunal may sit elsewhere for the sake of convenience. For example, we sat online during COVID. Some of us sat even from foreign country during COVID. So sometimes arbitration tribunal can sit in some other place, which is not the place of the legal seat, I would say. That doesn't change the fact that the law governing arbitration will be the law fixed. So if it's Singapore, seat is in Singapore, it is the law of Singapore that will govern the proceedings of the arbitration, whereas the applicable of contract may be different. For example, the applicable of contract may be English law, and arbitration may be seated in Singapore, whereas we come to Bangladesh for an interim relief. So that doesn't really change the concept of the seat. Seat should always be static. I hope I could clarify.
May I
But
ask a question?
Is this point clear in the Bangladesh Arbitration Act?
It's not. We have used the concept place, but it is from the framers of the model law. And if you read the literature in different laws, we can have a more unanimous view that place and seat can be used interchangeably without much confusion anymore. But that doesn't mean that
then easy solution to the problem would be if these judges have orientation to arbitration. They don't. Many of them probably don't have. So that's the problem. And it's a good suggestion that this course should be taught in the undergrad level, so that students come out with the mindset of arbitration and ADR, in other words, in general. Okay, thank you very much.
Sorry, just one. We struggle every day because arbitration law requires a lot of analysis of contract law, a lot of commercial law, and often we get students, often we get interns who are not really up to the mark, and as a result, we suffer. That is the reason why I think academia should actually be more proactive into this.
Yeah.
Thank you.
If the law schools are strong, then judiciary will be strong, practice will be strong. I think.
Absolutely.
It's a good suggestion. Thank you.
Thank you,
Thank you.
Prof. So well, thank you again, Dr. Khaled, and also the Prof. Anwar Zahid for the question and answer. And also, again, apologies for those who like to ask questions, but I think we just cannot entertain because of the time limit, extremely limited for this session. So